Welcome students to this video series on incorporation. Business associations begins with the meaning of business, but businesses themselves begin with the incorporation process, which is what we're going to talk about in the next series of videos about how to actually start a new business venture in the form of a corporation. In this video series, we're going to cover 3 topics involving incorporation. The first being incorporating a Delaware corporation and some of the decisions involved in whether or not to incorporate in Delaware or elsewhere, and then the process of how to go through that. 2, defining corporate powers. There's a doctrine called the ultra vires doctrine, which states that if a corporation acts outside of its corporate powers, that action is unlawful. We're going to try to avoid that. And third, speaking of lawful activity, as lawyers, we need to think about legal ethics. Legal ethics come into play in incorporation in some unusual ways because we're representing a situation, not necessarily any individual people, although they may think we represent them. So we're also going to need to delve into some of the legal ethics of incorporation to really understand the lawyer's role in this process. The ultra vires doctrine deals with corporate activity, which is beyond the scope of the corporate purpose. So it used to be the case that corporate purpose had to be very, very clearly defined in a corporate charter or certificate of incorporation. And so historically, corporations had to specify every conceivable purpose that they might have so that they could engage in a wide range of business. And there were pages and pages of these purposes in the Articles of Incorporation. Modern statutes don't require this. Modern statutes allow you to say any lawful purpose. And by saying any lawful purpose, any lawful activity is by definition not ultra vires. So if you simply draft your articles of incorporation properly, this doctrine doesn't need to apply to you, which is great because it's a tricky one. So the exception being the bar exam, where the bar examiners seem to like to put these questions on the exam, but truly is outdated. This just never comes up in practice. So that said, let's jump in and talk a little bit about the ultra vires doctrine and how to avoid getting into trouble on the bar exam, and for that matter in practice, and maybe why we should always put any lawful purpose in our certificates of incorporation. The certificate of incorporation is a pretty simple document. It doesn't require a lot, although they can be lengthy depending on the complicated capital structure. But in general, we're going to simply have the corporation's name, its registered agent, its authorized capital, and its corporate purpose. So we don't have to stipulate a corporate purpose very specifically anymore. It used to be the case that we did. Now we can just say any lawful purpose. But if we do state a purpose, then the issue that arises is whether that purpose is within the scope of the whether an action that the corporation takes is within the scope of that stated purpose. So if you don't state any lawful purpose, but state a more specific purpose, then any further actions may be subject to the ultra vires doctrine if the court finds that it is beyond that purpose. After the incorporation, the corporation can begin actually acting. So it can actually start taking actions. And to ensure those actions are not ultra vires, you either need to define the corporate purpose to include every action that could be taken, or to say any lawful purpose. In my opinion, much better to say any lawful purpose and avoid the ultra vires issue with actions taken after incorporation. Just as a quick note, after the incorporation, the action typically taken is called the action by incorporator, and the action by incorporator is to call the organizational meeting, and at that meeting, the incorporator will cause the board to be assembled, will elect the board, and will pass the power of the control of corporation from the incorporator to the board. And so that will usually occur at this stage as well, in this initial action. Again, that has to take place within the powers of the corporation, but it should have any lawful power if you've filed the proper documents. At this organizational meeting, the directors will be elected and appointed. The bylaws should be adopted and attached. The officers should be named and appointed. It should be authorized for the officers to create a bank account. And the initial stock should be issued so the corporation has a stockholder. The election of the directors must happen at the first meeting because a corporation must have one director. And interestingly, in Delaware, the director must be an individual. It must be a natural person. It cannot be a corporation or a partnership or some other entity. It's interesting. Why not have a corporation as a director? Todd Henderson wrote a paper called Boards Are Us, where he thought maybe the world could be otherwise. But back to requirements, you do not have to name or number how many directors there are in the certificate of incorporation. You can simply say they'll be set as time to time by the board. And if not numbered, so we're going to actually set that in our organizational meeting, which is going to be one of our first actions. And again, that organizational meeting, we're going to avoid it being ultra vires and avoiding anything in the future being ultra vires by having any lawful purpose. But what we want to look out for is, did the board do anything during one of its meetings which was beyond the scope of its purpose? That can trigger an issue with the ultra vires doctrine. Again, that only comes up if the purpose of the corporation is defined more narrowly than any lawful purpose, which is sort of an archaic way of doing things, and should not be an issue today, but may come up from time to time on the bar. Next, we're going to talk about the legal ethics of incorporation, because when we incorporate a business, we become the attorney to the business, and we're not actually the attorney to the individuals that incorporated it anymore. So we're going to suss that out a bit in our next video, and I'll see you then.